Hello and welcome back to our channel. Today I will be talking about whether or not your spouse gets an equal share in property that you bought before marriage. There's two kinds of properties. There's the matrimonial home and there's all the others. Okay, so if it is the matrimonial home, then yes, you don't get a deduction. Your spouse will share in that property, even though you might have owned it before the date of marriage. Now, for all other property, however, they do get to share it to the extent that they share the increased value of the asset. So what I mean by that is when you're calculating net family property, you will get a deduction for the value that that asset was as of the date of marriage. So if that property has now increased in value, you still get to share, the increased value, but you get a deduction for the value of that asset as of the date of marriage. So I don't know if you can technically say that they're getting an equal share. Well, actually, you can't say that because they're not really getting an equal share in the value of a property that you purchased before the date of marriage, but they do get an equal share in the increased value of that asset that you purchased before the date of marriage. So let me explain this let me use an example that would maybe kind of ground it a little bit more. So let's say you owned, an apartment, for example, that you were renting out to people. And as of the date of marriage and up until the date of separation, it remains a rental. So we're not dealing with a matrimonial home here. So that rental property, let's say it's valued at, $500,000, for example, at the date of marriage. And now on the date of separation, it's valued at $1 million. So there's $500,000 equity that has accrued during the marriage. In the calculation of equalization, or of your net family property rather, you will share that $500,000 of increased value with your spouse. Obviously, that's a very simplistic way of putting it. There are other factors that go in. Obviously, there might be debt associated with that asset. There could be notional disposition costs that could be appropriate, possibly capital gains, things like that. But I just want you to get the idea that yes, you do share the increased value of that asset, but not the full value. And that's because the Family Law Act allows you to get a deduction for assets that you owned as of the date of marriage. So you do literally get a date of marriage deduction. So that is great news if that's what you're trying to accomplish. Unfortunately, for a lot of people, the property that they're living in as of the date of marriage is a matrimonial home that might have been purchased before marriage. And I know that is something that is very heartbreaking for a lot of people, to find that they don't get the date of marriage deduction. And a lot of times people ask me and they don't understand why that's the case, right? Because if they can get a deduction for that investment property, well, why can't they do it in this property? They're content sharing the increase in value, but they don't understand why they have to, share sort of the full value of a property that they had purchased before marriage. And the answer is, it's just the way the Family Law Act is written. There are ways around that, obviously, but an example, is if you have, if you purchased a property as of the date of purchased a property that became a matrimonial home at some point during the marriage, and then you subsequently sell it before the date of separation, then that's fine. If you do separate, you could still get a date of marriage deduction for that, right? But if it's a matrimonial home and continues to be a matrimonial home, even though you owned it as of the date of marriage and you purchased it solely before then, it really wouldn't make a difference. You still get to share the full value of that home with the other spouse. So I'm just trying to think of also when you're also looking at sharing the equal value of assets as well with the other side. You want to it doesn't matter whether or not that asset exists as of the date of separation. That's something people often miss as well. They would, remember assets that they own, but they don't want to make that part of the net family property calculations because they no longer own those properties. So that doesn't matter. So provided you owned that asset as of the date of marriage, it is appropriate for you to get that date of marriage deduction for the asset. Okay, so coming back to the original question, will my spouse have equal share in property purchased before the marriage? No, they don't get an equal share in property that you purchased before the marriage, because you get a date of marriage deduction, but they do get an equal share in the increased value, the increased equity in that asset that has accrued during the marriage. So I do hope you found this video informative, and if you have any questions, do not hesitate to put them in the comments. Do send us emails to our firm. We're here to help, and we're happy, to answer your questions and maybe provide additional videos to clarify. And do hit that subscribe button so you can, get more informative videos like this in the future.